Okay, hello and welcome everyone to our webinar, Creating and Selling AI-Generated Art and Understanding Your Legal Considerations. My name is Chris Elias and I'm the practice leader of the Web3 and Fintech practice at LegalVision. And it is my pleasure to be joined today by Cassandra Hood, who is the social media and community building manager of NightCafe Studio, and a renowned artist, Peter Gric. So thank you both for joining me today. I guess before we begin, we'll just set some, quick housekeeping sort of rules, and just to give you an idea as to how this is going to go. For everyone who's registered for this event, we will be sending you a copy of the recording as well as some information materials. So don't worry about taking frantic notes. It's all good. You'll receive a copy of this after the webinar. Feel free to submit your questions as well in our Q&A chat box below. We'll do our very best to answer those at the end of the general discussion. And after the event finishes, you'll receive a survey, and we'd very much love you to, complete that. Your feedback is very valuable, and it'll help us deliver this type of presentation a lot better in the future. So we definitely appreciate that. Okay, so today we'll be discussing, some key topics. The first being copyright and AI art. The second will be protecting your work from copyright infringement. Third will be protecting yourself from, committing copyright infringement. And finally, the ins and outs of commercializing your work. All right, so at the end of the webinar, we will be answering some of your questions, as I mentioned. So please do feel free to submit those in the chat box below. And again, we'll do our very best to answer them at the end. I thought we start off by, let me start off by saying this is not legal advice. We'll be talking about things at a relatively high level here. So definitely consult with your lawyer or speak to us after the fact if you do need, if you do have a specific question that relates to your specific circumstances. But like I said, we'll do our best to give you some really practical information that you can walk away with and have a better understanding as to the legal implications of AI-generated art. Okay, so Peter, I'll turn it over to you. I think you have a list of questions there that you could ask me, and I'll do my best to answer them.
Yeah, hello. Yeah, thanks for having me here. It's for me something that I'm not doing very often, so I'm not very familiar with this kind of setting, so bear with me.
It's all good.
So now I'm not sure if I should say some introduction about myself or if I just can go right to the questions, which is on my queue list here, which would be what is copyright? So this is the question I'm supposed to ask first, and
well, I mean, it's a good place to start, I think, and it might be a good idea to just start off with some basics, and then we can dig deeper into that. So I guess copyright is essentially a legal right that gives a copyright owner, like the author of a piece of work, exclusive rights to use that particular work in any way they would like, right? Which includes the right to commercialize, make modifications, create derivative works, and so on. This legal right is found in the Copyright Acts. In Australia and the US, they're both called the same, the Copyright Act. And its primary intention is to protect the expression of ideas or forms that the ideas may take, rather than the ideas and concepts themselves, right? So this means essentially literary works, music works, artistic works, things of that nature. So that's that. Peter.
Okay, how does an artist? How does an AI artist copyright their artwork?
Yeah, so this is a tricky topic because AI generated art and copyright is, there's no sort of clear direction on this, and we'll kind of explore that now. So I guess for a work to have copyright protection, it's important that it's one, original, and two, has some skill or effort involved in creating it, okay? So this means that copyright law in the context of AI-generated art considers the following elements. So the first being the type of work. So copyright protection and AI generated art is strengthened if it's a literary, dramatic, musical, or artistic work. Artistic works include paintings, sculptures, drawings, things of that nature. And the second, this is a really important point, is originality. So this is largely determined by the nature and type of work, as I described above. And in the AI context, how the AI program actually operates and how it was used to generate that work. And finally, the level of intellectual effort required by the user of the AI program to produce that work. So all this is considered when a court or someone determines originality. And finally, and this is a key point and probably the most important, which is human authorship. So copyright laws in Australia and the US require a human as the author, and you must also demonstrate that human involvement was influential in creating the AI generated work, and that the AI generator was merely a tool used to create the work, as opposed to being primarily responsible for the output. So effectively, if the factors described above are satisfied, then you will have copyright protection as soon as the work is created, right? So you don't need to register or anything. Although I will mention that the US does give you the ability to register to strengthen your right to copyright protection, and that is done in the US Copyright Office. I'll just continue on this point a little, because I think it's important to consider what the context is at the moment and what the legal position is in certain jurisdictions, and I'll primarily focus on Australia and the US. So the Australian and US have generally been reluctant to recognize copyright for AI generated artworks. The US Copyright Office, the USCO, has ruled that AI generated artworks cannot be copyrighted due to the lack of human authorship, particularly on the basis that the intellectual labor from a human author is required to receive copyright protection. So in a lot of these cases that have been put before them, that most of those works haven't satisfied that threshold. Similarly, in Australia, again, courts have reasoned that works produced by computer programs do not usually satisfy that requirement of human authorship, as the human author or the actual work does not pass the independent intellectual effort test, right? I will note that the UK is currently considering laws to grant copyright protection over computer generated works. So that is something that is currently, I guess, being considered at the moment. It's not, active yet, but it might come into being. And unfortunately, case law doesn't provide sufficient clarity on this just yet. But again, this is a topic that is currently being discussed. I guess I will mention many artists in the industry that are using AI-generated art. There is a strong argument to suggest that there is significant intellectual effort involved in creating AI-generated artworks based on the methods and practices that artists sort of go through in creating their works. Peter, a little later down the track, I will ask you how you sort of, go about your process. It would be interesting to sort of learn about as well. But I guess, just to finalize this point, Lainey, if you can go to slide 5, I can show you some examples as to what might receive copyright protection and what probably won't, right? So the first one you can see, I've played around with the NightCafe Studio AI, and it was really fun. Actually, I had a good time. This image here, or these 4 images, was generated by the AI generator, and I simply typed in a prompt, red chair, and this is what it produced. I used the dark fantasy mode, I guess, and this is what I produced. Now, based on, I guess, the 3 elements that I identified earlier, it's safe to say that there wasn't any intellectual effort involved or skill or labor involved in creating this artwork, because I simply typed in 2 words and produced this. So it is very unlikely that this will receive copyright protection in the Australia and the US at the moment. Now, if we go to the next slide, this is a little bit different. So I've added a few more, I guess, prompts to this. I've been a bit more descriptive. Now, the artworks generally look a lot cooler, obviously, which is great, but there is a little bit more of a case for me to demonstrate that there was a bit more intellectual effort involved. Again, Peter's probably looking at this and saying, definitely not, Chris, you're not cutting it, but it's, at least I have some leg to stand on here, so there is some argument that I can have to say that, you know what, I did think about this, I did have an image, and the AI tool allowed me to create something that I visualized in my mind. So yeah, I guess that wraps up that point, and hopefully that sort of gives you an example as to the copyright issues there.
I have a question.
Yep.
You could have done this in Photoshop, and it would be pretty much the same, basically. How can you tell if it's AI or if you did it by yourself? I mean, does it make any difference actually? Or if there is a discussion, this is made by AI. Nobody was there was no human involved, but you can say, hey, I did it in Photoshop. This is not AI.
That's a great question, and I guess it's, if it was to be examined, and if you were to present your argument that this should have copyright protection, if you designed it in Photoshop, then you could demonstrate that you were using your independent or intellectual effort, skill, and labor to produce that artwork. And it's fairly easy to prove that, because, again, you would have sort of renderings, draft versions of the artwork done in Photoshop, and then you use that to produce the final work. But if you were to produce it through an AI program and all you did was write a few prompts, then it's unlikely to pass that test. So it's how you get there more so than what the finished product looks like. Does that answer that question, Peter? Sort
of, yeah. I have another question. There's this interesting discussion about what is, if it can be protected because it's made by, I mean, the same thing, but then you have artworks like ready-mades. I can just go here and say, okay, this is now art. This thing here, or no, this one, this battery. It's art. I just decided this is art. So, but there is not such a discussion with anyone. Like legal authorities, because I just decided this is art. It was not done by AI. Is this somehow, can I compare this with the problem with the machine-generated art?
Yeah,
But I have now problems with the internet connection for some reason. I don't know if it's on my side. Can you hear me?
Yeah, no, we can hear you, Peter.
Hello?
I think, yeah, Peter, we can hear you now. Looks like you're cutting in and out a little bit, but I guess, Peter, I heard you, and I think that's a really interesting topic. And you're potentially identifying an issue in copyright law that copyright law doesn't actually consider. Again, copyright law and copyright protection is there for people who have expended some intellectual effort, labor, and skill in order to produce a particular artwork. Now, for the ability for people to copyright, a battery, I think you held up earlier, and then call that art, poses some policy issues and policy questions that the government doesn't want to introduce. Like, if I were able to pick any item in my room and say this is now art, I think that would be quite difficult from a policy perspective for the government to then provide people with protection, if that makes any sense. But look, it's certainly an interesting topic, and definitely one that needs to be heard if you as an artist feel that that's a gap in the law, and that things like that and artworks like that deserve that copyright protection. But I guess this leads nicely onto the next topic. Peter, are you still with us? Okay, looks like we've lost Peter. So Cassandra, maybe you can ask the next question about how AI artists can best protect themselves.
Yeah, that's definitely one of the questions that kind of float around in the community is how can AI artists protect themselves from infringing upon copyright or the copyright laws?
Yeah, great. Okay, well, I mean, this again can be inherently difficult since AI generated art is generated by software, which requires a extremely large data set to learn from. And artists who use these tools typically don't have control over the training data that get used to train the AI. So, I understand that real world context there. But in ideal situations, I guess, if you could have the ideal situation, you will need to ensure that you have the right to use all the images used to train the AI model. So as I just mentioned, this is harder to control, of course, but if you are using a third-party generator and you don't have this control, then you should avoid using words and prompts that describe someone else's artwork, right? So an artist will be able to provide you, if you were to infringe on someone else's art and an artist wanted to protect their copyright, then they would be able to easily prove that you breached their copyright on the basis that you were using prompts that describe their artworks almost directly. So definitely avoid using prompts like, I'll give you an example. If you use words like Beeple and Elon Musk, I'm just foreshadowing a little bit here.
Chris.
You
frozen.
You are likely to be breaching copyright if, in fact, you're in the artwork that you generate. What was that?
You froze there for a second.
You there, Cassandra?
Yes. Are you able to hear me?
Oh, cool. All good now?
Yes.
Yeah, I got you.
Okay.
Yeah, cool. So no, just continuing on this point with Beeple. So if you were to describe a particular Beeple artwork like the Elon Musk example, then again, it's likely that if people wanted to sort of exercise their right to protect their copyright and in court say, basically it will come out that you were using a Beeple prompts and words to describe that artwork, it is likely that you would infringe on that particular copyright. But anyway, look, I guess, Peter, if you're with us, it'd be interesting to hear about, how you go about generating your artworks, because they're amazing, and it'd be great to sort of see that example.
Okay. Can you hear me now? Am I online? Because I had a problem with the connection quite some time, and I heard only fragments of what we were saying the last couple of minutes. But now it seems to work. I changed my hotspot to my hotspot of the phone, so I hope it works.
It's working a lot better.
Okay. So I don't consider myself as AI artist, actually. I'm playing with this stuff just maybe half a year when I noticed that it's becoming really serious. I didn't pay much attention until maybe April or something before I just saw it and I thought, okay, this is not interesting, but at some point it started to be very interesting, but not only in a positive way, but actually scary, because it starts to compete with us artists, actually, in a very weird and peculiar way. So I had the possibility to just to ignore it and say, okay, it doesn't bother me. I'm a painter anyway, because I'm actually a painter. I'm painting paintings in a traditional way, sort of. I do use computers since ever, but in a different way. I'm just designing my concepts in 3D and so on and so forth. But so I could ignore it, or I could just go and look at it, and because I'm curious, I wanted to see what can I do with it. Can I use it as a tool at least? And the idea was, okay, this stuff is using, or this thing is using the content of artists, obviously. So why should not I use, as an artist, the content that this stuff is producing, or this, and maybe put my art again on top of it.
Yeah, Peter,
So,
that's really interesting. I'd like to sort of explore that a little further. So how do you draw inspiration from other people's artwork? I mean, is that part of your process? Do you see art,
yes,
and then do you draw inspiration from them? Yeah,
of course. I don't believe that you can create art out of nothing. So there is always this aspect of you know, some input from the outside, and this can be, of course, other artists, especially other artists. In my case, it started with my father, who was my mentor, and he kind of introduced me into the arts. And then many other artists, and many of them, or a few of them, you will recognize in my artwork, or many people do recognize them. But it's not just that; it's also technology. Just the aesthetics of technology, of architecture, and especially of the nature. So I'm usually going with my camera, or lately with the phone, and whenever I see something interesting in the nature, be it a piece of wood or a stone or clouds or whatever, I take pictures, I put it in my archive, and I have it, and I look at it sometimes just and I let it, you know, can I say?
it inspires you.
Yeah, I let it inspire me, and I'm looking at it, and I wait until it ignites some idea, or it resonates somehow with what I'm just now looking at with my art. You know, the motives, the themes, what I'm interested in. So
that's great.
There is always some input from the outside. And then is this element which is spontaneous, which is, I would say, from the inside. This is just like when you go on, or when I go on a receiver, and I have all the data or all the elements I found interesting, let's say photographs or inspiration from other artists or AI, and then I just sort of meditate on it, or I just wait, and I go on receiving, and then I might get inputs from somewhere else, and these inputs are not vision, you know, from sensory or from the outside in that sense, but from something I would call the system, the inspiration, the system, the part which is beyond determinism, beyond causality, because everything else is like sort of cause and effect. I see an interesting painting by I don't know, by some artist, and it triggers something in me. So there is this aspect of cause and effect. And this is a very big part of every artistic process. But inspiration and this human aspect, this is the other very important part. It's a mixture of both, I believe.
Yeah, that's great. And that's perfect, Peter. Thanks for that. And Cassandra, I guess just using that as context, potentially, or help frame this, how does the AI tools that you use sort of work at a high level? I'm not going to ask you to go too deep.
Yeah, I thought it was really interesting how Peter was saying he gets inspired by things. He'll kind of remember and draw from that when he does want to create something. That's kind of what AI does. So it's kind of modeled after the neural pathways of the human brain. That's how it gets trained. They feed it millions, sometimes billions of images. And from there, it kind of, if you type in your prompt, so let's say a dog sitting in a grass field, it's going to think of all of those images that it's been trained on and draw from memory what it thinks it looks like. So it's not necessarily drawing or copying artist's work and bringing it into existence and just kind of like remixing it. That's what a lot of people seem to think AI art is, but it's more kind of actually like what you do or human does, bringing something from your imagination to fruition. So,
yeah, that's great, Cassandra. It looks like we've lost Peter, but we'll press on anyway. That was really insightful from both of you. And I think, I guess, you know, when we talk about breaching or infringing on someone else's copyright in the context of using an AI tool, I've got a couple of examples. If we can go back a couple of slides to the Elon slide. So I actually tried to break the tool deliberately, and I basically used prompts that would likely allow me to infringe on Beeple's copyright. So on the left, you can see the Beeple copyright, Beeple NFT art that you'll see there, and I effectively tried to trick the AI tool to replicate that. It produced something quite interesting, and to your point, Cassandra, it just strengthens that a little bit, that these tools are relatively sophisticated, you know, there's NightCafe Studios in particular, and it does sort of draw inspiration, sort of mimicking how artists, you know, like Peter, will sort of draw inspiration from their environment, collect that data, and then produce an artwork. So I thought this was pretty interesting, and despite my best efforts, I don't think this will necessarily breach any copyright. You know, there's an arguable case here, but potentially not. If we can go to the next slide, though, I was a bit more successful in this. So I was able to sort of, you know, if you see, particularly, you know, on the left is the famous Banksy artwork, and on the right is my sort of artwork there using the tool, and I used, you know, prompts that would allow me to sort of infringe on that. And particularly the bottom two images in that 4-image thing on the right there, you'll see that those girl images in particular, they are very similar, if not identical, to the Banksy artwork. So there's a strong case that I'll be infringing on copyright there. So I guess, you know, the takeaway from all this is be careful with the prompts that you're using, because they do impact on how on what artwork is generated and can potentially lead to copyright infringement. But, you know, of course, don't go ahead and use a bunch of descriptive words that describe someone else's artwork, because it's pretty clear and it'll be very easy to prove that you are copying someone else's artwork. Thanks for that, guys. That was really cool. I think we've covered all those questions. I think, Cassandra, we're going to talk about commercialization right now.
Yeah. So pretty much something that we wanted to ask, just to clarify for artists, is if, like, what exactly is commercial purposes if you're not selling your AI art, or versus selling your AI art?
Yeah, I guess, you know, it's an interesting question. You know, commercial purposes is not really defined. I guess it's more just any purpose where you use any of your intellectual property or use your copyright for any commercial activity. So, you know, that is primarily to generate financial returns. And that includes selling your artwork as well, right? So, you know, other common examples is, you know, using an image and using it on merchandise or clothing or something of that nature, leasing any particular intellectual property, or creating derivative works to be able to use that in some commercial activity. If you're an artist and you've created an original work, you know, then you can use it for any lawful purpose, and you can use it for commercial purposes. So again, if you create your own work, use it for whatever purpose lawful purpose you want. However, if you are creating work and you use another person's intellectual property, so you use a particular sort of artistic element, you know, I know there's a site called Dribble where people, you know, create and display a variety of graphics where they license particular IP to other people for them to use in their artworks. What you need to make sure of is you have like a written agreement or written consent from the owner of that IP and intellectual property, for you to use that element or their intellectual property or their copyright in intellectual property for a commercial purpose. And you have to be clear as to what that commercial purpose is. Now, a lot of the times it's, you know, if you have something that will allow you to use it for commercial purposes, you'll have a pretty broad range and pretty broad scope. But sometimes there are sort of limitations on commercial purposes, and I guess how you could use another person's intellectual property. So common examples of this include like a geographic location. So you can only use my intellectual property in your artwork for commercial purposes in Australia, and that's it, or in these listed jurisdictions. So, that is definitely something to take care of. But of course, if you've created your own intellectual property and you own the copyright, and you own all the intellectual property rights associated with that, then of course you can use it for any commercial purpose, any lawful commercial purpose, I should add.
Awesome.
So,
yeah, that answers my question for sure.
Cool. Cool. I think we have a couple of others. I guess there's one relating to NFTs. Do you have that there?
I do. So that's pretty much is, how can you sell your creations as NFTs and prints without legal repercussions?
Yeah, again, it does touch on a lot of what I mentioned before. So if you do own the intellectual property in an NFT, for example, or like an image associated with that NFT, then you can, if you have the right to use it for commercial purposes, you can use it for commercial purposes, but you need to make sure that you have that right. So you have to be particularly careful, and you have to definitely look at and determine whether or not you have a license to use that intellectual property for the purpose that you would like it to use. You could find those rights in the terms of sale or in the terms and conditions of a particular site, or some license contained in the NFT itself. Now, NFTs are notorious for sort of omitting this and not having these terms very clearly described. But I think the industry is sort of aware of that now, and will definitely look to improve on that as we go. So it's a little bit tricky, but definitely look for what rights you have over the image. And if you don't see any, then clarify that with the NFT creator or person you bought that from, if you can. Sometimes they're anonymous, so that's a bit difficult. But
yeah.
Cool.
Awesome.
All right, I think that concludes that. The general questions.
Yeah.
Cool. So I guess we'll get to Q&A in a sec, but before we go on to that, that concludes our discussion of the sort of basic headline topics that we want to cover here today. Again, we do have a fact sheet. So obviously there was a lot that we discussed today. We've given you we've sort of distilled that and summarized that in the form of a fact sheet, which you can download in the webinar panel there. So hopefully that's quite helpful. I guess, before we get to Q&A, again, feel free to submit your questions. I think we just have a few slides on, who the guests are today. Cassandra, feel free to, speak about yourself and what NightCafe Studio is doing.
Definitely. So I'm Cassandra. I'm sure a lot of people have interacted online with me. If you're interested in asking any questions or learning more about NightCafe, you can reach out to the team at hello@nightcafe.studio. And of course, you can always visit our website or any of our socials, where I'm usually online in the Discord. So that's where you can find me specifically. And we also have a special offer for all of the webinar attendees. So for November only, if you use the code LEGAL25, you get a special 25% off your first pro purchase. And that's, again, for the first payment only. And this is only for November. So if you're not a NightCafe Pro member already, now's the chance to get in on this deal.
Awesome. Peter, feel free to talk about yourself. I mean, I've definitely check out that website. The artworks are really amazing. But Peter, yeah, feel free to share a bit more about you and how people can interact with you.
Yeah, well, I'm quite active on Facebook, because this is still, for me, even though I don't like Facebook, but it is for me still the most biggest audience, so to speak. So this is one way how people can get in touch with me, or through my web page, of course. Yeah. Where can I start? I mean, this whole discussion about AI and is it art or it's not, and so on and so forth. I was always using computers for the concept art or the concept work for my paintings. Already in the early 90s, I was totally into 3D, and so it was always a very important tool for me. And So I see it now with the AI, or I'm trying at least, and I get in a lot of discussions with people about this problem. And many of my fellow artists, they are literally scared of this technology, and they, especially those who are working just digitally, that they are afraid they are running out of business at some point.
Mm-hmm.
And I understand that. I mean, I'm concerned myself as well, although I don't really sell digital artworks. I mean, I did sell last year and the year before NFTs, but I'm not so much into this anymore because this was like a hype, and now it's over, it seems. But I'm painting, I'm creating original paintings, and I'm selling these. So even when I use AI, and I also use now for my last paintings, or the last painting which I'm working on, I was also using partially NightCafe. So it's a very interesting tool, of course. But
yeah, awesome. I think
it's still I still create something beyond information. It's a real thing you can actually hang on a wall. It's a painting. It's a piece of it's an object. And I think this makes it easier for me to still, you know, you need. I still use my hands and my eyes and everything to get this thing together, even though I have a reference which is made by AI or partially, or however I put them usually more things together.
Well, I think the key takeaway then here, Peter, is it's very likely that all of your works are going to be covered by copyright protection, because it looks like you put a lot of thought, effort, and skill into it, as opposed to just using a tool to generate something. So, you know, that's a good takeaway in the law sort of working on your side there, and potentially the way you use it, you use these tools could just be quite helpful. But yeah, no, that's great. All right, so I guess, you know, we can talk about, you know, me. I sort of gave you all an introduction on who I am. Again, I'm pretty active in the Web3 space, and you know, as a default, I've sort of gone into AI generated artworks because, as Peter mentioned, you know, a lot of people are selling NFTs, so I understand that quite well. But yeah, I guess broadly about LegalVision and the law firm that we're at, I'm very proud to work at LegalVision. You know, we're a new age law firm. We operate quite differently. We have a membership model, which effectively allows you to pay a membership fee, and that includes you know, unlimited sort of contract drafting and reviews, consultations with lawyers, you know, a range of perks as well that are associated with that, corporate structuring sort of related matters as well. So definitely, you know, it's sort of a new way to deliver legal services, and a new way to sort of get legal support there in a commercially beneficial way for a lot of, you know, early stage businesses and, you know, startup founders. Great. And also don't forget as well, so we do actually have a special offer as well at the end of this webinar. Feel free to reach out to us, because I'm sure you might have other questions. Again, we'll get to Q&A in a sec, but you know, definitely sort of reach out to us. We'd be happy to give you a complimentary call to talk about your legal issues. Again, just feel free to cite this webinar as well. But yeah, we do have that support. Again, our services are mainly located in Australia, the UK, and New Zealand. And we can also support you in other jurisdictions by referring you to and working with our colleagues internationally as well, outside of those jurisdictions. So definitely feel free to get in touch there. All right, so should we get into some Q&A?
Yes, I see a really good question, and this is something I just recently got asked too. So something that's been floating around the community is, what's a historical figure and a public figure? So like here, someone said, is it 70 years after the death of an artist that you can use their artwork?
Right. So typically copyright protection. So I'll answer this in the context of copyright. Copyright protection is typically the life of the author and then 70 years after they pass. So that's generally the period of copyright protection they have. There are other things that are, I guess, relevant to consider here, which is, whether or not certain copyright and intellectual property right transfers onto someone else, and they have sort of a right to use and a right to protect that particular copyright as well. When it also comes to public figures and, living public figures, for example, I know this is a question that gets asked a lot, whether you can use like real celebrities or public figures in that context. That's not so much a copyright issue, but it's more of a privacy related issue, and various jurisdictions have laws around that. So definitely be careful of that. I will note though, you can't copyright a person or someone's like likeness, because as we discussed, it's not, it wasn't created by intellectual effort, labor, or skill. That person's likeness or image, they just are people, and copywriting people's likeness is a bit of a slippery slope when it comes to policy related issues. But but there are privacy related issues that relate to that as well. So that's something to be mindful of.
That's good to know. It's more of a privacy issue versus a copyright issue. Awesome.
Right.
So if someone were to actually challenge your ownership of the AI art, like here, someone asked, how would they get access to your prompts to show you copied something? Would the AI art generator, the platform, be responsible for turning those over?
Yeah, well, I guess if it got serious enough and you were asked to produce, you're compelled to produce information in a court proceeding, for example, then yes, it's likely that someone is going to request that, or the court or the other party will request evidence to ask what prompts were you using. So it is likely that will come out in a court proceeding, and there's nowhere really to hide there, because that data and that information does exist in a database. So you can't hide behind the idea that, well, it doesn't exist or anything. It's there. There's a record of it. So yes, it will come out in the wash.
Good to know. Awesome.
Yeah.
So another great question we got asked: can AI artwork be licensed, although it cannot be currently protected under copyright law?
Sorry, can you ask that again?
Yeah. So can AI artwork be licensed, although it cannot currently be protected under copyright law?
Right. Okay, so I guess you can certainly do your best to protect your intellectual property rights, your broader intellectual property rights around this. There are intellectual property law. It does include like things like trademark and patents, although that's not really relevant in this context. But certainly from a trademark perspective, yes, you can trademark certain names and logos and so on. I won't really talk about that, but let's talk about copyright in this context. And let's say, for example, you've produced an AI generated work and you're not sure whether or not it has any copyright protection. It doesn't stop you from trying your best to protect what you've created. So I would always suggest that if you are, you have produced something and you would like to demonstrate ownership of the license, ownership of the intellectual property rights associated with that work, then it's best to create a license around that to then attach to or used as part of the point of sale. So the contract in which you use to sell your artwork, and you talk about the transferal of intellectual property rights in that artwork over to the other person. If you don't want to transfer the rights entirely and you want to grant people a right to license that work, then yes, it's always good to have a license that you enter into with the other people who want to use the work. So use a license agreement to govern that and to structure that. You might get pushback if someone wanted to be particularly cheeky and challenge that there is no copyright protection associated with this. then yes, you would have to sort of challenge that and potentially defend your copyright protection there. But I guess that's something that, again, you don't need to concern yourself with. It's best to just operate using best practices, and the best practice is to use a license agreement to protect your broader intellectual property rights in that artwork.
Cool. Awesome. This question I think would be kind of interesting, even for Peter to hear. So how are the styles of living artists protected from infringement, and what ethical safeguards are in place?
This is an interesting one. Using, sorry, ask that again, please.
Yeah. How are the styles of living artists protected from infringement, and what ethical safeguards are in place?
Right. That's a particularly interesting one. I'm not sure I have a good answer for that. I guess, certain intellectual property rights, I guess, can continue, provided that those rights are transferred into like another estate, for example, and that estate can then manage and govern, or protect the intellectual property rights of that particular artwork or styles, for example. But styles in themselves will not receive copyright protection, again, because it's not. I guess styles in themselves will not receive copyright protection because, again, it's too broad, and unless the style is really original, then again it may receive. But yeah, I guess, look, this is one of those situations where it will come down to the specific facts, and depending on what the facts are, maybe it'll apply, maybe there is some protection. But yeah, that's a loaded question, I think.
Yeah, definitely. So
cool.
For the last question, can you create or sell fan art? So art that's made using celebrities' names or their likeness?
Yeah, so again, I guess we touched on this earlier. I mean, this is a good question, and this comes up a lot. In the context of copyright, again, you can't copyright likeness or someone's image, I guess, but you can, there are a variety of sort of privacy laws around protecting public figures' likeness and exploiting that for commercial purposes, particularly. Now, let's look at the Beeple example, where he uses Elon and all these public figures regularly. Again, he won't necessarily breach copyright because, again, you can't copyright someone's likeness, but you may breach certain privacy and sort of, privacy and surveillance sort of issues as well. So that's another area that I'm not particularly aware of. I know that does exist, but that becomes sort of that is a relevant consideration. Now, if you're sort of defamation is another sort of area as well. If you're portraying someone in a negative light that damages their credibility, that's another entire area. But it's worth sort of considering or understanding that there are these considerations from a policy and privacy perspective, and it's definitely worth keeping that in mind. But if you create a pretty interesting work that person, if it's Elon, for example, and he likes your artwork, then he's not going to do anything. But there's always that risk that someone doesn't like it and they don't want you to use their artwork for whatever reason. So keep that in your mind. But from a copyright perspective, again, that you don't really have that protection over likeness.
Good to know. Thank you.
Cool. Okay, cool. To wrap up, thanks, Cassandra. Thanks, Peter. I think we're good. Just to wrap up today, please do request a complimentary consultation. Again, we've discussed a fair few topics here today. Again, a lot of the devil is in the details, so please do take this in with, I guess, at a very high level. These issues are very complicated and do very much depend on the detail. So if you do have a specific question, or you do want to speak to a lawyer about something, definitely reach out to us, and we'll arrange a time for us to chat. All right, so that concludes our presentation. Thank you all so much for joining. I had a great time. Cassandra, Peter, thank you so much for joining me. Great questions, great insight. Peter and Cassandra, both of you, it was a pleasure.
Thank you, Chris.
Same here. Thanks, guys.
Thanks, Cassandra.
Thanks, guys.
Thank you.